right? It's just the office of the White House creating that, whatever law it was, right? So that's why it's so, in a way, fluency that the next president can change it. When a law actually has gone through all of this process that we just saw, then it's different, right? Yeah, it requires the president's signature as well, but then it cannot just be overturned by the next president like an executive order will. Does that make any sense? Those two differences, I just want you to make sure that you remember that part about how that one works. And then of course, like we saw there, if the Congress passes a bill and they send it to the president for signature and he is against that issue, he can just veto it. He can just say, no, I don't agree with it, I'm not even going to sign it, it's not going to become a law, right? And then in our system, this is just kind of for more knowledge sake, there is such thing as overriding a veto, right? It's also a difficult process, right? And overriding a veto is kind of when the person has vetoed something, then Congress can go back and vote and kind of veto the veto, if you will, right? So, but again, we're just going to leave it at what we have. All right, so when it comes to our judicial system, we think of it as a neutral finder of the facts. And that's a good example of that is when we have, in our courts, we have the judges and the juries. They are the neutral finders of fact. And the key word there is neutral, meaning that they're actually trying to be objective. They are just going by the facts, right? And what the law says about that particular issue. In other words, what we would like to think about it is that there is no really emotions or our personal opinions involved when we are trying to come up with an outcome or with a verdict, right? It's neutral, all right? So there are three functions of the United States court system. The first one is to administer state and national laws. The second one is to resolve disputes among parties. And then the third one is interpret the legislative intent of a law in deciding a case. What does that third function mean? When you see this third function here, kind of like walk me through it. What does that one mean? Oh, that wasn't rhetorical. What does that one mean when you see that one? What does that one mean? That one of the functions of the United States court system, because this one we kind of can see, they administer the state and national laws, there was all these different parties, and then we get to this last one that I just wanted to kind of dive into a little bit deeper and kind of see what does that one mean? Interpret a legislative intent of a law in deciding a case.
Does a case have like binding precedent, or is it like open for interpretation? If it is, like, how do they interpret that towards the case?
Yeah, and how it fits that particular scenario, right? Okay, so because it's so a lot of the law. I mean, sometimes we have cases or we have scenarios in which it's real clear cut, right? X equals y or whatever it is. Y equals X, right? We have that kind of this means this and this equals this, right? But there are certain areas or certain cases in which we have kind of that wiggle room, some people call it gray area, in which, so is that law that we have in the books from about this actually fits this? Is it supposed to be this? And that's what, that's what pretty much what the Supreme Court does, right? Because they actually try to figure out, okay, so the Constitution, when it was written about this particular topic, do they intended this, and they actually meant this particular thing, or they actually left it for this other side of things, right? So it's actually kind of getting that debate going about whether a legislative part of a law actually fits particular cases, right? And then we have the federal system versus the state system. What do you think are the differences between those two systems that we have going on?
Federal, national, state, the state.
Okay, all right. And what an individual or a group of people that find themselves in an issue that needs to be resolved, how would they go about deciding whether they want it or should have it here, their case heard at a in the state system or the federal system? And B, how would the system itself tell you as a citizen, okay, we are here to hear your case, so you can come to us as the state system, or you are trying to get us to hear your case here at the federal level, and you pretty much don't qualify for it, right? So that's kind of what I'm trying to get at. There are certain cases that just wouldn't qualify for it to be here at a federal court, right? And then vice versa, right? There are certain cases that the state system couldn't handle. It's more of a matter of more of a federal court type of system, right? And so it depends on the characteristics of the cases, right? So the federal courts are going to take on cases that deal with violations of the Constitution or any of the other federal laws, right? We have also the notion that they would hear disputes among or between citizens if the issue at hand exceeds the amount of $75,000. They also hear cases like bankruptcy cases, copyright, patent, maritime law cases. So it's more, overarching. The state courts are going to be hearing cases most of the time that have to do with robberies, traffic violations, broken contracts, family disputes. And it cannot hear cases against the United States or specific federal laws, right? So let's say that another country has an issue with the United States, or a citizen has an issue with the government and kind of brings a suit against the government, then a state court wouldn't be the place to have that hearing, right? It will have to be at a federal court. Also important to note about this is that the main difference between the federal courts and the state courts lies on the notion of jurisdiction. And what is jurisdiction?
Say that again?
The main difference between the two courts, the federal and the state, lies on the notion of jurisdiction. All right? All right, and so jurisdiction, so my question was, what is jurisdiction?
It's like control over an area.
Yeah, it's control
Yeah.
over an area, it's control over, it's pretty much having the power or authority to, it's having that authority to exert power over, an area or a certain group of people, right? So state courts kind of like their jurisdiction is limited, that's why we have like things like bankruptcy or copyright, that kind of broaden the jurisdiction of the federal government, and that's why they go to the federal court system, right? For instance, if you are an individual conducting business in Colorado and you have an issue with an individual conducting business in Texas, then it becomes a matter of jurisdiction. You probably want the case heard here, they probably want the case heard over there. So there will be like those conflicting jurisdiction things. That in itself makes the case to be able to be brought to a federal court instead, right? So that you don't have to kind of worry about the jurisdiction that one of the parties is going to get an advantage like a home sort of a bench, if you will. Make sense? Questions, comments?
What is maritime law?
Maritime law is that has to do with the oceans, and sometimes it's like the right to either exploit the natural resources of the ocean, right? Like fishing and drilling for natural resources like gas, oil, that type of thing, right? But sometimes it's like, most countries, well, not most countries, a lot of countries are surrounded by water, by oceans. And so there is this boundary of, how many miles outside the ocean actually a country can claim that is part of their, sovereignty, if you will, right? So sometimes countries decide or think that, hey, you're saying that you're still controlling the waters 200 miles outside Florida, right? And some countries might say, hey, but our country is closer than that, so you're pretty much taking part of our waters, if you will, right? So there are laws that control that type of deal, and so we have the international courts that sometimes get involved because of those maritime laws where the some countries disputing that type of deal, right?
Okay.
Oh, you're fishing in our waters, or you are doing this, that type of thing. All right, or exploiting our minerals. We kind of claim that part, belongs to them. All right. Any other questions or comments about that? All right, we move on. So more on the judicial system, we have the American judicial system being based on common law principles. And what it means two things. It means that precedent is used in a lot of the cases that we have. So, what is precedent? So it is binding authority versus preserved authority, but precedent pretty much means that we have had cases that have been, resolved, or an outcome has been passed on those, and then when we get other cases that are very similar with this pretty much similar circumstances, we refer to those previous cases, right? To argue either against or in favor of those, depending on what side of the aisle we find ourselves in. So the decisions that were made in previous cases become the guidelines for present or future cases with the same characteristics. That's one way that you could define precedent, right? On your own words, describe precedent for me. How do you understand it? Say that again?
A set standard?
A set standard. That's another way, a pretty good way to describe it, right? And the way is because we don't want to try this person a certain way, like you're saying, with certain standards, and then we have, another individual committing the same type of crime with the same characteristics, and then we kind of apply different sets of standards to kind of go about trying that people, right? So the trials have to be the same. If this person is allowed DNA evidence, this other person is supposed to be allowed that. DNA evidence should also be allowed here because the issue, the crime, was similar, right? And so on and so forth, right? If we are suppressing this here, we have to suppress this there. If we are allowing this here, the same thing should be allowed on the next one, right? So it's that present. The same thing that we handle one case, we handle the next one with the same characteristics, right? Obviously, there are some things that not everything can be exactly the same, but the most fundamental, the most what you call pivotal parts of the trial should be utilizing that precedent, that set standard, right? Because again, if you don't do that, then the person, the defendant, if that person gets convicted or the ruling is against that person, then they can easily appeal on the grounds, that the trial was mishandled or whatever, right? They didn't utilize the present notion, right? And then status, stay or decisis also pretty much means using present. So yeah, so from this one, I want you to kind of remember that present is that notion of utilizing previous cases, previous decision in cases, and how they were handled to handle present or future cases of similar characteristics, right? All right. And then of course you have both criminal versus civil law. In both of those instances, utilize present, right? If you kind of at the federal system, you had a case that dealt with mail fraud or that type of deal, embezzlement, and whatever standards that you realize for that case, you're gonna use in the next one that you get that is similar. So when we're talking about criminal law versus civil law, what do we know about that? What's different about them? What's similar about them? Let's discuss. Criminal versus civil law. Yes, Brad?
On the sense. I don't know, it's just like, murdering someone versus stopping in a street
That's it, right? It's kind of a severity is one of the things about it, right? So, and it is pretty much that those, and I'm pretty sure that when you said murdering someone, you were talking about criminal,
Yeah.
and then the other one was civil, and that's absolutely it. It's kind of a severity. The criminal law is more of those gross acts against the violent acts against the community, right? It's some of the characteristics of a criminal law would be an injury to the public, obviously, violent crimes, murder, rape, kidnapping, etc., right? They are prosecuted by the government, so it's usually the government is the prosecutor, and then the person, because it's usually a person, is the defendant. So that's actually pretty important for you to understand that there is that dynamic government versus the defendant. That's why usually you hear the term the people versus so and so, right? So it's the government versus the defendant. In the criminal law, an attorney is provided by the state, by the government, if the defendant is unable to afford one. Then the burden of proof is another key difference between the two laws, right? So on the criminal law, the burden of proof is beyond the reasonable doubt. What does that mean, and why do you think is here on this side? Why does the burden of proof on the criminal side of things is beyond the reasonable doubt, and why do you think that is important? Yes.
I think it's again because of severity. So like if you're gonna convict someone of murder versus like embezzlement, if you're wrong about murder, that's way worse than
Exactly.
wrong about embezzlement.
So I hear you saying because of what is at stake, pretty much, right? And it's exactly true, right? I mean, if, like you're saying, if you are to convict or kind of accuse and they eventually convict somebody of murder, and where the punishment, the sentence could be, pretty much imprisonment for life, or even in some states, the ultimate penalty, which is the death penalty, right? Then you better be pretty certain, beyond the reasonable doubt that the person that is there is the right person, right? So that's kind of one of the reasons for that. And again, convictions, if the person is actually found guilty, the conviction may result in civil disabilities or loss of liberty. So again, here the stakes are higher because the person's freedom is at stake, right? The defendant's freedom may be on the line if convicted, right? So again, penalties potentially include loss of liberty. We are not really talking about the one that I already mentioned, the ultimate penalty, but that's also within the realm of possibilities on criminal law, as we all know, right? Then for civil law, we are talking about things like a private injury or wrong, and this is what we as sport managers or any other career that you may find yourself in are more concerned with. Hopefully, none of this will ever touch us, will ever get to us. But if anything, that will be kind of the things that we will be dealing with in a sports setting, right? Civil side of things, right? Somebody getting injured in your facility, right? That type of or your event, somebody is slipping and falling and then, suing you for that kind of idea, right? So the plaintiff sues the defendant, person to person. Parties must provide their own attorneys, so it's not like the criminal cases. If you cannot afford one, the government is going to provide you with one. No, here you must furnish your own attorney, right? You must come up with your own attorney. Can you still hear me? All right, here the burden of proof is preponderant of the evidence. What does that mean? See how mouthful that was? Preponderant of the evidence. Preponderant. I like to say that word. Preponderant. Anyway, what do we think that means? Preponderant of the evidence. Here we had that the burden of proof was beyond the reasonable doubt. We kind of already figured that one out. Now let's figure this one out. What do you think that would mean in the civil side of things? Yes.
It's more important than the evidence has been showing, in a sense. So it has more of a importance.
Okay. Can you give me an example?
The outward influence of the U.S. in the alliance.
Okay. Yeah. And to put it a different way, is preponderance of the evidence pretty much means that in civil cases, the burden of proof is only that the plaintiff side of things, side of the argument, has to prove that the defendant was more likely than not to have been the cause of the issue, of the injury, of the wrong. Did that make any sense? The suing party, the plaintiff, has the burden of proving that the defendant was more likely than not to have been the cause of the injury or of the wrong, right? So you see, it's not beyond the reasonable doubt. It's more like it was more likely you, right? It was more likely you the one that did it, pretty much. Right? So you can see kind of how the burden of proof is a little bit different, right? Here we have no doubt. Here we just kind of prove that more likely than not, right? That's kind of the standard. Does that make any sense? All right. So there is not really civil disabilities and or loss of liberty because the penalties are usually monetary in nature, right? So those are the two differences. I wanted to point out that once we have the verdict, also the lingo changes and it's a way to differentiate the criminal versus the civil law. And here, when we have a verdict, we would find the defendant here we will to find the defendant guilty or not guilty of whatever the charges were brought on him, right, or her. On the civil side of things, the limit changes to what? When the verdict or the outcome comes out, what usually it sounded? What does it sound like? What is it? Is the defendant is found liable or not liable, right? So those are also two differences between the two systems or laws, if you will. Here you're gonna have a guilty or not guilty verdict. Over there, the outcome is gonna be liable or not liable, right? One more thing, I don't know if I already kind of brought it up, but here, in this side of things, on the civil law, the cases are usually brought on the basis of individual suing another individual. That's kind of the usual setup, right? The individual suing another individual. Right? And here, government versus individual. All right? Comment, questions, concerns? Yes.
So in cases of like embezzlement, because that's what I think of with like civil law, I know people have gone to jail for that, so when does it tip the scale? Like, is it when somebody decides it's a public harm?
Yeah, like sometimes it's like a public entity or that has connections to the federal government with banks, and so what they do is like, because a lot of these transactions, you know, either electronically or they happen in a way that because the postal service is a government entity, so they can kind of utilize like bank fraud to bring one of the charges and then have the federal government to have jurisdiction over that. Does that make any sense? Yeah. So it's more about like the channels and the means that they utilize that have that allow the federal government to have jurisdiction over those cases, right? Does that make any sense? Yeah. It's like it's because of that side of things. Yeah. Here it's more like individual, like just within one city, kind of doing wrong on other individual, that type of deal, right? Yeah, things like bankruptcy and copyright and all that usually has a way of finding themselves on this side of things. Just because, again, because of the actions sometimes are gross, that it can actually be harm for the public at large. You know, like Enron, everybody knows about that. This guy kind of got that notion. And everybody got hurt. All of us were because of that. All right. So criminal law, we have like assault, battery. You know, there's kind of a couple of examples of it, and we're gonna be looking at it when we actually look at negligence and all of that. But that's kind of it falls under criminal law. One of the things is that it kind of branches out when we look at it from the civil side of things, because we can have assault and battery also they can be considered civil, and then what makes the difference is the intent, right? So you can have a case in which either you can be assaulted or you know, you could assault somebody unintentionally, right? And then, or not intentional, but the intent will be, you know, that it wasn't your intent, that the notion will be that it wasn't your intent, and so that would fall into civil law. It's called like a tort law. Now.
But would that be unintentional, or is that?
Oh yeah, no, it's intentional. It's intentional. It's just that under tort law, we have certain degrees in which you can have civil cases, and then at the same time you can have a criminal case. That's the best way that we're gonna explain this slide. There are certain cases that fall under both, right? So you can have assault and bring it under civil system, civil law, and at the same time you can have that same case under criminal law, right? Because and the reason is, yes?
Oh, just to say like in a car accident, so if you have passengers that are injured, it could be. fall under both.
Exactly, that's a very good example. And the reason why we can have it both ways is because if you pursue a civil, it's a criminal offense. But, okay, scratch what I said at the beginning. Assault and battery are always gonna be a criminal offense, right? But here, when you take it to the criminal side of things, you are kind of or the government actually will be the ones who take that, right? So they're actually looking to punish that person, the government is trying to let them know, hey, this is not okay, and so we're gonna punish you, and probably what they're gonna try to seek is for that person to be sent to jail, lose their freedom, right? So that will be the criminal side of it. But you as an individual can actually bring a lawsuit because of the same incident, trying to get some damages, meaning some money, right? Some monetary compensation for whatever it is that happened to you. So that's pretty much what this slide is showing us. That certain cases, like assault and battery, will fall under the two, because on this side, you have the criminal side, prosecutors, try to send the person in jail for what they did, and you as an individual trying to recoup, trying to get some compensation for the same incident, right? So that's why, and a lot of the times we see, especially with what we have seen, a lot of the misbehavior of a lot of these stars that we have seen. I think that, what's his name? Weinstein was just, is that his name?
Harvey Weinstein.
Yeah, Weinstein. He was again in court today, so, you know, it's one of those things where he does a criminal offense, right? So he's being prosecuted by the government, but then eventually, or I think that currently, he would also have some civil lawsuits brought to him by the victims, again, you know, trying to recoup something or whatever it is that they are looking for. So that's kind of the explanation of this slide. You can have the two cases going on, right? Or somebody can be actually charged in the two systems, if you will. Does that make sense? Did I confuse you enough from that one? Hope not. All right. So we also have what is called the alternative dispute resolution. So we've already talked about how our laws work, the court system work, who brings a lawsuit against whom, what the burden of proofs are, what the potential outcomes or convictions are, the lingo of it. But then we also have these other alternatives, right? And again, this is usually in civil matters. I mean, we would see this on the criminal side of things. But on civil matters, you have these alternatives to actually bringing a case to court, in front of a judge, of a jury, right? So you have, the first notion is that one of arbitration. And arbitration is a decision that is made by a neutral decision maker, which is who is